SwayamPrabha. Digital India. Educated India.
Hello viewers, welcome to SwayamPrabha. We are doing a course on Procedural Law on Crimes, Bharatiya Nagarik Suraksha Sanhita 2023. Today is the fourth session, it's a part of that course. I am Professor Vageshwari Deswal, a Professor of Law at Faculty of Law, University of Delhi. I, along with my colleague Dr. Saurabh Rana, will be delivering this course. Today, we will be dealing with law relating to arrest. So viewers, let us first of all try and understand what is arrest. The term arrest has not been defined anywhere in the Bharatiya Nagarik Suraksha Sanhita. But then, what does the term imply? See, arrest means apprehension of a person by legal authority resulting in deprivation of his or her liberty. See, if I put a person in a room and lock him from outside, would that amount to arrest? The answer is no. That would in fact amount to wrongful confinement. Why? Because although I have apprehended a person, although I have put restrictions on the personal liberty of that person, but I am not a legal authority. I am not a person authorized under law to do so. But suppose I was asked by some legal authority, by some police officer to do that, then in such cases I would not be guilty for wrongful confinement. So what is required is that there must be some sort of a restraint on the personal liberty of an individual, and that should be done either by a legal authority or by someone who is authorized by such legal authority. So arrest, it can be done by a police officer and it can also be carried out by private individuals subject to the condition of authorization from that authority. So if we try to define arrest, we may define it as a formal mode of taking a person into custody. And now what is custody? When we talk about taking a person into custody, what does that mean? Custody indicates the state of being under someone's care, protection or keeping. In law, custody means being under surveillance and also implies some restrictions on movements of a person. Now, arrest and custody, these are two terms which have different meanings. These should not be used interchangeably. Why? Because in every arrest there is custody, but in every custody there is not necessarily arrest. So what is the difference between these two terms? Let us talk about this in detail. See, there was this judgment, Niranjan Singh versus Prabhakar. This is a Supreme Court judgment of the year 1980, in which in para 7, the court remarked, when is a person in custody within the meaning of section 439 CRPC? See, this is the old provision of CRPC. Before we got BNSS in 2023, prior to that, the procedural law on crimes in India was the Criminal Procedure Code. Since we as of date do not have new judgments on the basis of BNSS, that might take some time, but the concepts are the same. So in order to understand those concepts, we can rely on the old judgments. So what the court said? When is a person in custody within the meaning of section 439 CRPC? When he is in duress, either because he is held by the investigating agency or other police or allied authority, or is under the control of the court, having been remanded by judicial order, or having offered himself to the court's jurisdiction and submitted to its orders by physical presence. So, no lexical dexterity nor precedential profusion is needed to come to the realistic conclusion that he who is under the control of the court or is in the physical hold of an officer with coercive power is in custody for the purpose of section 439. Then in the judgment which was delivered by Supreme Court in the year 2008, State of Haryana versus Dinesh Kumar, the court further elaborated on these concepts, and the court said, this word is of elastic semantics, but its core meaning is that the law has taken control of the person. The equivocatory quibblings and hide and seek niceties sometimes heard in court that the police have taken a man into informal custody but not arrested him, have detained him for interrogation but not taken him into formal custody, and other like terminological dubietics are an unfair evasion of the straightforwardness of the law. We need not dilate on this shady facet, because here we are satisfied that the accused did physically submit before the sessions judge and the jurisdiction to grant bail thus arose. So, after talking about the difference between arrest and custody, now let us talk about how a person can be arrested. So, whenever we talk about arrest, we say that a police officer directly went and arrested a person, but then sometimes a police officer needs a warrant before he can place a person under arrest. See, there are two kinds of cases that we discussed in the previous lectures, cognizable and non-cognizable. Now, cognizable offences are slightly more serious in nature, due to which what happens? The police is supposed to act promptly. And in case they were to first spend time in procuring a warrant from the magistrate, in the meantime maybe the accused could make good his escape. There is a possibility that the accused might in the meantime tamper with the evidences, he might try to influence the witnesses, he might try to remove his footprints or digital footprints. So, what is required is that whenever they get information as to the commission of a cognizable offence, they are supposed to act very, very promptly, and wherever required, they can also conduct arrests without waiting to first get a warrant from the magistrate. On the other hand, there are cases which are slightly less serious in nature, and they are non-cognizable offences in which the police may arrest, but only after first obtaining a warrant of arrest from the magistrate. So, you see, arrest can be done directly, it can be done by the means of a warrant. So, what is an arrest warrant? So, arrest warrant is a written order signed, sealed and issued by a magistrate, and it is addressed to a police officer or some other person specifically named in that arrest warrant, and that order commands that person, who could be the police officer, who could be some other person, to arrest the person named in such warrant. So, when the police officer or other person has to conduct an arrest in the furtherance of such warrant, what is required is that they should act in good faith. That is, when they go to arrest a person, they have to exercise due care and precaution in ascertaining whether the person who has been named, whose details have been given in the warrant or order, are the same, are matching with the person whom they are arresting, and then after exercising due diligence, they are supposed to arrest that person. So, what are the essentials of arrest? What constitutes arrest? First, there has to be an intention to arrest under authority of law. Second, there has to be a physical seizure or detention of the arrestee in a manner that is recognized by law. So, both these need to coexist. In case you have the intention to arrest a person, but you have not physically placed a person in detention, that would not amount to arrest. Similarly, if you have placed a person in detention, suppose accidentally, you were not aware, there is a person sitting in a room, you just go and lock the door from outside. Now, you do not have the intention to arrest that person. So, that would not amount to arrest. So, you see these two conditions, they are necessary to constitute arrest: intention plus the actual act of placing the person under detention or putting some restrictions on the movement of that person. It is only when these two exist in respect of the same person at the same time that it constitutes arrest. Then the important question is, why do we need to make an arrest and why is arrest made? See, Article 21 of the Constitution of India, it guarantees right to life and personal liberty to all of us. So, we all have a right to live and we all have a right to be free, because that is the personal liberty. So, no one can be deprived of his right to life or personal liberty except according to procedure established by law. So, if the procedure established by law authorizes that yes, a person can be arrested, he can be deprived of his liberty for whatsoever time period, then in such cases, in accordance with the procedure which the law has established, a person can be arrested. So, why do we arrest? First is to secure attendance of accused at trial. But then, see, just because a person is accused or suspected of a crime, does that mean that we will go and arrest that person? The answer is no. See, the courts have time and again emphasized on the fact that arrest should be done only when the accused's attendance is not likely to be ensured by notice or summons. See, if this is a person who is not likely to flee from justice, if there is someone who is cooperating with the investigation, he is not trying to hinder the investigation in any manner whatsoever, then there is no need to arrest the person. So, arrest is to be done only when we know that this person would otherwise not cooperate with us, he would not be present for investigation whenever he is required, or maybe we would not be able to secure his attendance at trial when the case would be put on trial. In such cases only we are supposed to arrest, not otherwise. Then arrest can be made as a preventive or a precautionary measure. So, there are people who there is a capability that those persons, they might be engaging in some crimes. There is a possibility that they might disturb public peace. There is a possibility when the unlawful assembly, even after being commanded to disperse those people, they are continuing with the unlawful activities. So, sometimes what happens that there might be a necessity that before their actions translate into some criminal actions, they need to be apprehended and they need to be placed under preventive detention. So, it can be done as a preventive measure, it can be done as a precautionary measure. See, there are some states in which whenever there is a festival, there is a huge frenzy amongst the people, there are huge crowds and there are antisocial elements who take advantage of the crowd and they do certain crimes. The police more often than not has information about those people. So, in such cases the police may either ask that person to leave that territory for the time being. These are externment proceedings. That is in case there is a possibility that otherwise this is a person who is going to engage in crime. Or if that is not possible, then for temporary period that person can be arrested. Then arrest can be done for obtaining correct name and address. See, this is to be done only when the police is asking this person the correct details, the name of that person, the address of that person, where the person can be reached. But the person refuses to provide correct information, gives conflicting information, wrong information. Then in such cases, because the police is not trusting the bona fides of such a person, then in order to obtain correct name and address of such a person, the person can be arrested. Then sometimes for removing obstruction to police, The police has to reach somewhere on time, the police has to do certain activities, but there are people who might be involved, who might be hand in gloves with the criminals. They might be trying to distract the police, they might be trying to obstruct the police. So in such cases, if they are trying to create obstructions to the police in the due performance of their duties, then to remove such kind of an obstruction, the persons may be arrested, and then it can be done to retake a person who has escaped from custody. See, once we have arrested a person, placed a person in custody, and the person somehow manages to give us the slip. In such cases, the police is authorized to pursue that person and retake that person in custody. So, now let us talk about the law. What does the law say? Law relating to arrest of persons has been laid down under chapter 4 of the Bharatiya Nagarik Suraksha Sanhita, that is sections 35 to section 62 of the BNSS. Previously, the provisions were under sections 41 to section 60A in the CRPC. So, first of all, let us try and understand when can the police arrest without a warrant. See, if they have a warrant, they will directly go and they will conduct an arrest. But if it is a serious crime and when you are supposed to arrest even without first bothering to obtain a warrant or before wasting time in obtaining a warrant, what are the things that are to be kept in mind? As I said, arrests, they are not to be conducted in a routine manner. What does the law say about this? So, it says, any police officer may, without an order from a magistrate and without a warrant, arrest any person, A, who commits in the presence of a police officer a cognizable offence, or B, against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied. So, what are the conditions that the police officer has to be satisfied about before he proceeds to conduct an arrest? 1. The police officer has reason to believe on the basis of such complaint, information or suspicion that such person has committed the said offence. So, you see, whether he receives information via complaint, whether somebody has come and registered the FIR, or even suo moto, he can take cognizance if he has some sort of a suspicion, someone has told him about that, or he himself has that suspicion that the particular person has committed the offence, then the police officer should have reasons to believe. Okay. I mean, again here we would be ascertaining the bona fides, that is, he should exercise a reasonable care and precaution before proceeding to place a person under any kind of a custody. Then the police officer is satisfied that such arrest is necessary to prevent such person from committing any further offence. That is, see, if the police officer is satisfied that in case I am not going to arrest this person, he will not stop. He will continue in his spree of commission of crimes. So, in such cases arrest becomes pertinent, or for proper investigation of the offence. See, if the person is not arrested, he might tamper with the evidences, he might try to influence the witnesses, he might not cooperate with the investigation, he might try to mislead the authorities, plant some false evidences and all such things. So, if there is a reasonable apprehension with the police that this person will not let us conduct proper investigation of the offence, then such person might be arrested. Or to prevent such person from causing the evidence of the offence to disappear or tampering with such evidence in any manner, to prevent such person from making any inducement, threat or promise to any person who is acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer. So, you see in clause C and clause D we are talking about why it is important to ensure that the witnesses, they are not disturbed, the evidence that is not tampered, and in case there is any such possibility that we can arrest the accused person. On E says, as unless such person is arrested, his presence in the court whenever required cannot be ensured, and the police officer shall record while making such arrest his reasons in writing. Okay. So, what are the reasons? Why were you prompted to make this arrest? See, police does not have unlimited powers. They have certain powers, but they are the powers that have been given to police officers to facilitate them in the performance of their duties. So, whenever they have to exercise their duty and towards that end they have to exercise certain powers, they should have some justification to exercise those powers, especially when we talk about arrest. What are the conditions that necessitated this person to conduct the arrest? See, for the longest time our courts have been warning police officers not to conduct arrests in a routine manner, and that is why there have been amendments in the law, and now when we have the law in the present form, it categorically states that the police officers, whenever they arrest a person, they have to record. See, when you feel that otherwise this person is not going to cooperate with us, we cannot secure his attendance at the trial, then you are justified in making the arrest. But what were the reasons that made you arrive at this conclusion? So, you would have to record your reasons. Then, provided that a police officer shall, in cases where the arrest of a person is not required under the provisions of this subsection, record the reasons in writing for not making the arrest. Okay. In case you have not made the arrest also, then also you are supposed to record the reasons. Okay. So, whenever you are trying to deprive a person of his personal liberty, you have to record the reasons why this person has to be arrested or why this person has not to be arrested. So, what are the guidelines to be followed while making arrests? Now, Supreme Court in the case of Arnesh Kumar versus State of Bihar had issued certain directions to prevent unnecessary arrests by police officers and unwarranted detention that is authorized by magistrates. So, Arnesh Kumar versus State of Bihar, this is a landmark judgment. The guidelines that were laid down by the courts, they are very important and they are something which every police officer needs to know, and every individual also needs to know if in case there is any suspicion or in case there is an apprehension that the person might be subjected to arrest, this is the law which a person has to know. Although this was a judgment which was given in the context of misuse of the old section 498A of IPC, that one in which a woman, she can allege cruelty at the hands of her husband or in-laws, whether that is in relation to demand for dowry or otherwise, and because that is a cognizable offence. So, it was noted that police officers, whenever they would receive such a complaint, they would conduct arrests in a routine manner. See, all the family members of the groom, they would be arrested, including maybe if their sisters, they were not even staying with the family, they were staying somewhere outside, their relatives who were not even in regular touch, but if the girl would mention their names, then all of them would be arrested in a routine manner, because this was a cognizable offence, and rightly so, because it was required to be enacted as a harsh measure to prevent women being subjected to cruelty. But over the years, it was seen that the way the provision was drafted, making it cognizable, making it non-bailable, making it non-compoundable, what happened in such cases? The courts, they were compelled to remark that a watchdog had been transformed into a bloodhound, and there were so many instances where law was being misused. So, what happened that these guidelines, they were sought to be laid down by the Supreme Court, and this was an opportunity in Arnesh Kumar versus State of Bihar, in which what did the court say? State governments must instruct their police officers not to automatically arrest someone when a case is registered under section 498A of the IPC. arrest should only be considered if the situation aligns with the criteria outlined in section 41 of the CRPC. Then all police officers should have a checklist containing specific clauses mentioned in section 41(1)(b) subclause 2. When producing the accused before the magistrate for further detention, the police officer should submit the checklist along with reasons and evidence justifying the arrest. Next, magistrates, when authorizing further detention, should rely on the report provided by the police officer. The magistrate should only approve continued detention after recording the reasons furnished in the police report and after being satisfied with them. The decision not to arrest an accused individual should be communicated to the magistrate within 2 weeks from the initiation of the case. The superintendent of police can extend this time frame with recorded reasons. See, whenever you are to extend the time period, then also you are supposed to record the reasons for doing so. The accused person should be served with a notice of appearance according to section 41A of the CRPC within 2 weeks from the case's initiation. This time frame can be extended by the superintendent of police with written reasons. Failure to follow these directions could result in the police officer being held in contempt of court by the appropriate High Court. Judicial magistrates who authorize detention without recording reasons may face departmental proceedings initiated by the High Court. So, now coming back to what are the conditions for arrest, what does section 35 talk about? Then again, a person, in order to be arrested without warrant, who can be arrested? Then according to subsection C, against whom credible information has been received that he has committed a cognizable offence, punishable with imprisonment for a term which may extend to more than 7 years, whether with or without fine or with death sentence, and the police officer has reason to believe on the basis of that information that such person has committed the said offence. Or D, who has been proclaimed as an offender either under this Sanhita or by order of the state government, or E, in whose possession anything is found which may reasonably be suspected to be stolen property and who may reasonably be suspected of having committed an offence with reference to such thing, or F, who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody, or who is reasonably suspected of being a deserter from any of the armed forces of the Union, or H, who has been concerned in or against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists of his having been concerned in any act committed at any place out of India, which if committed in India would have been punishable as an offence and for which he is under any law relating to extradition or otherwise liable to be apprehended or detained in custody in India. See our Bharatiya Nyaya Sanhita, previously the Indian Penal Code, it has got territorial as well as extraterritorial jurisdiction. So, in furtherance of that, sometimes people might have to be apprehended, those who have committed crimes abroad also. Then I, who being a released convict commits a breach of any rule made under subsection 5 of section 394. See students, here what is the important term? It says released convict. Now here we are talking about someone who has been released subsequent to his conviction, but this is a person who was already also convicted on some account. Now what happens, this is a person who has repeatedly been convicted. So sometimes when he is released after his conviction, after his sentence is over, even post his release, certain conditions might be imposed on such a person because he is like an habitual offender. So the law might impose certain conditions on him that wherever you are staying, you have to communicate to us whenever there is a change in your address or change in your residence. That is something which has to be informed to the authorities. But what happens? That rule which is laid under subsection 5 of the new 394, if that released convict, he commits a breach of any such rule, then the person might have to be arrested. Then for whose arrest? Any requisition, whether written or oral, has been received from another police officer, provided that the requisition specifies the person to be arrested and the offence or other cause for which the arrest is to be made, and it appears therefrom that the person might lawfully be arrested without a warrant by the officer who issued the requisition. So when does this provision come into play? See what happens, a person might have committed a cognizable offence in one jurisdiction and then he flees into the other jurisdiction. Now the police officer under whose jurisdiction the crime was committed, he gets knowledge of the same, but he also knows that the person has already escaped into some other jurisdiction. In law, jurisdiction has got a very important significance. So there are territorial limits within which you can exercise your powers, within which you can conduct arrests. So if the person has already fled to another jurisdiction, so the police officer, what is the correct procedure to be followed? He sends a requisition to the police officer who is in charge of that jurisdiction, requesting that person to apprehend that person and turn him over to them. For that, they have to send a requisition specifying the details of the person who is to be arrested and why he is to be arrested. So the police officer to whom the requisition has been so sent, now that police officer is supposed to satisfy himself to the extent that yes, this person has, there is a reasonable suspicion that he has committed a cognizable offence. The information that has been supplied to him conveys this kind of an information, and thereafter he can conduct the, arrest this person without obtaining a warrant of arrest. Why? Because the accusation against this person is regarding commission of a cognizable offence, in which it is not necessary to obtain an arrest warrant before conducting arrests. Then, subject to the provisions of section 39, no person concerned in a non-cognizable offence or against whom a complaint has been made or credible information has been received or reasonable suspicion exists of his having so concerned shall be arrested except under a warrant or order of magistrate. Then the police officer shall, in all cases where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists. So, you see throughout this provision relating to arrest, there have to be these three things. One, either there has to be a reasonable complaint. Second, there has to be a credible information, or there has to be a reasonable suspicion. So, here also where any of these exists, that he has committed a cognizable offence, to appear before him or at such other place as may be specified in the notice. So, wherever arrest is not required, then they will issue a notice and the person will abide by that notice and help or support the police in conducting investigations by cooperating with them. Whenever he is required to be present at any place, the person has to be there. Then in such cases, it is no longer required to arrest such a person who is willfully cooperating with the prosecution, with the police in conducting the investigations. Now, where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of that notice. See, there is not a discretion with that person. It is his duty. Unless he complies with the conditions that have been laid down in that notice, he could be placed under arrest. So, he is duty bound to comply with the conditions that have been laid down in the notice. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offence referred to in the notice, unless, for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. So, what this means is, once a notice has been served that does not provide a blanket protection to the accused, that he will not be arrested in relation to that particular offence. He might be, if the police officer who is conducting the investigation feels so at any subsequent point of time during the investigation, and suppose that person, he conducts some other crime, not the crime for which he has been served the notice of cooperating in investigation, then he can be arrested in relation to commission of that particular crime. Then, where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offence mentioned in the notice. Then, the one that I have highlighted in red, subsection 7, this is a new provision which has been inserted by virtue of the BNSS. What does it say? No arrest shall be made without prior permission of an officer not below the rank of Deputy Superintendent of Police in case of an offence which is punishable with imprisonment for less than 3 years, and such person is infirm or is above 60 years of age. So, you see, even in cases of cognizable offence, but provided the imprisonment for that offence is prescribed as less than 3 years, or suppose the person is infirm, or in cases where the person is above 60 years of age, then arrests, they are not to be ordinarily made. In case arrest has to be made in such a case, then the police officer will have to first seek the permission of the concerned DSP. The DSP would have to be convinced about the reasons why it is required to arrest such a person who might be infirm, who might be old, that is above 60 years of age, or who might have committed an offence for which punishment is imprisonment less than 3 years. So, in these 3 category of cases, prior permission of the DSP is required before conducting arrests. Now, we are talking about arrests of people who are accused of a crime. Suppose the one who is accused of commission of crime is a judicial officer. So, are judicial officers totally protected against arrest, or can they also be arrested in case they have committed any crime? The answer is yes, they can also be arrested, but then judicial officers, they cannot be arrested in a very routine manner or in a casual manner. There are certain specified guidelines which have been laid down by the Supreme Court, and these were laid down in the year 1991 in the judgment of Delhi Judicial Service Association versus State of Gujarat. So, these are the guidelines that need to be followed before conducting arrest of a judicial officer. The law says, in case a judicial officer is to be arrested for any offence, an intimation to the district judge or the High Court has to be given immediately. In case there is an immediate arrest of a judicial officer of subordinate judiciary due to certain facts and circumstances, a technical or formal arrest may be effected. The facts of any such arrest should be immediately communicated to the district and sessions judge of the concerned district and also the Chief Justice of India. See, judicial officers, they hold a very important position. Judiciary is a very important organ of a democratic country. Judges, they are supposed to be above all sorts of suspicion. Judges, they are supposed to maintain the highest order of integrity and moral conduct. So, whenever a judicial officer is accused of commission of a crime and circumstances necessitate the arrest of such a judicial officer, so the information is to be given not only to the district and sessions judge, but see what does the law say? It has also to be communicated eventually to the Chief Justice of India. So, that is the kind of significance that has been attached to the arrest of a judicial officer. Then the arrested judicial officer is not to be taken to a police station without the prior orders of the concerned district and sessions judge. See, independence of judiciary is absolutely must, because we have a clear-cut separation of powers. You cannot allow any one of legislature, executive or judiciary to undermine the powers or functions or duties of any other organ of the government. So, that is why in order to maintain this independence, we have to give them certain concessions, certain powers. But sometimes what happens when the executive is required to arrest, but then before he is to be taken to the police station, a member of the judicial services, first what is required is that the police would have to seek prior orders from the concerned district and sessions judge. Then adequate facilities of communication with family, legal advisors and judicial officers have to be made available to the arrested judicial officer. Any judicial officer in any district, the highest officer is the district and sessions judge. So, any other judicial officer in that district, for that person the highest point of authority in that particular district would be the district and sessions judge, who is the overall in charge in terms of management of judiciary in that particular district. So, if a judicial officer is arrested, he should be given the opportunity of communicating with the district and sessions judge, so that he can appraise the district and sessions judge of the of his side of the story, or what actually the situation is, and thereafter the district and sessions judge is to take a decision whether that person is allowed to be arrested, or whether the judiciary has to do something to help a person who might be wrongly accused of any crime or whatsoever. But then monitoring, all this has to be done only after the consent of the district and sessions judge has been obtained in this regard. No statement should be recorded, nor any panchnama should be drawn, and no medical test should be conducted of the arrested judicial officer unless in the presence of the legal advisor or any other judicial officer of equal or higher rank. Judicial officer should not be handcuffed unless it is absolutely necessary for security reasons. See, one who has been appointed as a judicial officer, there is a lot of trust which the people, the judiciary, everybody reposes in that person. So, in case the person has actually committed a crime, the person has to be apprehended and tried, but in case the person has been wrongfully accused, see, judges, they hold a very sensitive position. Whenever they arrive at a decision, it has to go in favor of one person against some other person. So, it is but evident that they would be having some people who might be inimical to them. There might be a person who might be offended by the decision that the judge has to take in his judicial capacity, and not everyone is wise enough to understand that the judge is a neutral person. He does not have anything personal. There is no personal vendetta that the judge is seeking against any of the litigants. But then there are people who might try to unlawfully implicate judicial officers. So, we have to be mindful of this fact before allowing our judicial officers to be tried like other ordinary criminals, and that is why these guidelines, they have been specifically outlined by the Supreme Court in the judgment of Delhi Judicial Service Association versus State of Gujarat. Now, what is the procedure while making arrest, and what are the duties of an officer while making arrest? The law says under section 36, every police officer while making an arrest shall bear an accurate, visible and clear identification of his name, which will facilitate easy identification. See, the one who has been arrested has certain rights. So, the accused has to know who is coming to arrest him, who is the person by whom he has been arrested, and that is why it is important that the police officer who is making the arrest should bear his clear identification of his name. He should be wearing his badge. Then the police officer should prepare a memorandum of arrest. that has to be drawn up, which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. See, in both the conditions, where the arrest is made from the house of the accused, so any other member of his family. Now, why it is required to be attested is because we have to be careful about the time when a person is being arrested, whether the arrest is being done in a lawful manner, and yes, this is the one who was to be arrested. So, in order to ascertain all these things, in order also to ensure that the family members of the arrested person, they know that he has been placed in detention, and if they want, they can move the courts for his bail, or they can arrange for a lawyer or legal help and all these things. So, information is to be conveyed to the family members also. So, if a person is to be arrested from his house, this would all be satisfied in case they ask one of the family members of that arrested person to attest that memorandum, or it can be attested by any respectable member of the locality where the arrest is made. Okay. Suppose family members, they refuse to attest, then you can call a respectable member of the locality who will attest to such an arrest. Sometimes what happens, the person might be arrested from any place other than the person's house, from some other locality. Then there also any person from that locality who is a respectable member of that locality can be called to attest such a memorandum. It should also be countersigned by the person arrested. See, this is important, so that dates, time, place, all these things, they cannot be manipulated. So, one respectable person who might be either a family member of the arrested person or any other person from the locality, plus it should be countersigned by the person attested. So, this is to ensure that all the information that is contained in the memorandum of arrest is a true information. Then the police officer shall also inform the person arrested, unless the memorandum is attested by a member of his family, that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. See, suppose the person is not arrested from his house, or not arrested from a place where his other family members, relatives were present. Then in such cases, it is the duty of the police officer to inform him about this, that see, this is a right that vests in you. If you want, we will inform any one of your relatives, friends, family members, anyone whom you trust, to take steps to provide legal assistance to you or to take steps to secure your release. So, he has to be told that you have a right to have any other person, relative, friend, anyone whom you trust, to be informed that you have been arrested. Then section 37, now this is a new provision that has been introduced in the law. Now, this is relating to designated police officer. Before we got the Bharatiya Nagarik Suraksha Sanhita, we did not have a position of this designated police officer. This has been introduced by section 37 BNSS. It says, the state government shall establish a police control room in every district and at state level. So, you now see, there will be a police control room in every district. Additionally, there will be one control room at the state level also. Then what will the state government do? Designate a police officer in every district and in every police station not below the rank of ASI, that is Assistant Sub Inspector of Police, who shall be responsible for maintaining the information about the names and addresses of the persons arrested, nature of the offence with which they have been charged, and all this information shall be prominently displayed in any manner, including in digital mode in every police station and at the district headquarters. So, you see, in every police station, one police officer who has to be minimum of the rank of ASI, that person can be designated as a designated police officer. And what is the responsibility of such designated police officer? To maintain the record of all the people who have been arrested in that police station, and that all this information regarding what is the name of that person, what is the address of that person who is arrested, and what is the nature of offence with which he has been charged, all this information regarding all the arrests made in that police station, it has to be displayed at a conspicuous place in the police station. So, it can be displayed in any manner, like it can be put on the notice board, of that police station, or it can be put in digital mode, that is on the website of that police station. So, this information has to be there in every individual police station. At the district level, there would be one designated police officer who would be responsible for maintaining and compiling this information in respect of all the police stations within his district, and then there will be at the state level also compilation of information regarding all the arrests that have been made in that particular state. What all has to be recorded? Name of the person arrested, the address of the person arrested, and the offence with which the person has been charged. What is the nature of the offence? So, all this has to be done in order to ensure that arrests, they are not or hidden. Everybody knows who has been arrested, who has been apprehended. Sometimes what happens, there is a possibility. A person commits an offence in one jurisdiction, then he flees to another jurisdiction. There is a possibility that the accused might be required in relation to a crime which he might have committed in that other jurisdiction also. So, when all the data is available, so we know who have been already placed under arrest, in which police station they are. Secondly, the family members of the accused persons would also know that their family member, their friend or relative is in police custody where the person is lodged. All this information would be now available in the public domain. Then, right of an arrested person to meet a lawyer of his choice, to meet an advocate. See, earlier the term that was used in most of the procedural laws was pleader. Now, the term that is being used is advocate. And what section 38 talks about is right of an arrested person to meet an advocate of his choice during interrogation. So, the law says when any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, though not throughout interrogation. See, this is an important right, because when a person has been arrested, he is being asked questions. So, the Constitution says that you cannot be compelled to give incriminating statements against you. Then there is an absolute bar on torture to be used by the police. And then we also protect the rights of the accused by providing him an opportunity to consult his lawyer, so that he can talk to the lawyer as to how much he is supposed to divulge before the authorities. So, there is a right which vests in the accused person that during interrogation he would be entitled to meet his lawyer, but not throughout interrogation. So, now this is something which many times human rights activists, they raise an issue regarding this, that although we have given a right to the accused person, but why has this right been given in a truncated form? Why not throughout interrogation? Why only for some specified time during interrogation? See, we are supposed to protect the rights of the accused person, the rights of the arrested person, and rightly so. Why? Because on one hand, we have the police, we have the prosecution, we have the judiciary. On the other hand, there is the accused. See, the accused, but then we have to be mindful of the fact that the accused is not alone. There is our constitution behind the accused, which is going to protect the rights of such accused persons, and we need to strike a balance. Then arrest on refusal to give name and residence. Under section 39, the law says, when any person who in the presence of a police officer has committed or has been accused of committing a non-cognizable offence refuses on demand of such officer to give his name and residence, or gives a name or residence which such officer has reason to believe to be false, he may be arrested by such officer in order that his name or residence may be ascertained. See, whether the person has committed in his presence a non-cognizable offence. So, what happens? Before arresting that person, we need to obtain a warrant from the magistrate, because police cannot conduct arrests in cases of non-cognizable offences unless there is a warrant from the magistrate. So, whether the accused has committed the offence in the presence of police officer, or whether he has been accused of committing a non-cognizable offence, then in such cases the police will ask him his name and residence, so that the person may be conducted for purposes of investigation. But If the person, such person, he refuses to provide his name and residence, or he provides false information, then in such cases what the police may do? He may arrest that person in order that his name or correct address may be ascertained. And then when the true name and residence of such person has been ascertained, he shall be released on a bond or a bail bond to appear before a magistrate so required. So, the person has to be released because it is a non-cognizable offence, but then there is a condition that whenever you would be required to appear before the magistrate, you have to appear. This is the condition that would be put in that bail bond, provided that if such person is not resident in India, the bail bond shall be secured by a surety or sureties who are resident in India. So, some Indian residents would have to stand guarantee and provide surety for the presence of such accused person. Then section 39 subsection 3 says, if the true name and residence of such person is not ascertained within 24 hours from the time of arrest, or if he fails to execute the bond or bail bond, or if so required to furnish sufficient sureties, he shall forthwith be forwarded to the nearest magistrate having jurisdiction. Now, arrest by private person and procedure on such arrest. So, students, at the very beginning of this lecture, we discussed that arrest, it can be made by a police officer and sometimes it can be made by a private person. Section 40 talks about this particular aspect of arrest. So, how is the arrest to be made and what is the procedure on conducting such arrests? The law says any private person may arrest or cause to be arrested any person who in his presence commits a non-bailable and cognizable offence. So, what is required is that the offence should be non-bailable and cognizable, or any proclaimed offender. You have seen a proclamation regarding that person's name, and without unnecessary delay, but within 6 hours from such arrest, shall make over or cause to be made over any person so arrested to a police officer, or in the absence of a police officer, take such person or cause him to be taken in custody to the nearest police station. So, what the law says, that a private person can also arrest one, but only when the person you are arresting is either a proclaimed offender or the person is accused of having committed a cognizable and non-bailable. That is something which is very, very serious, in which the police may arrest without a warrant, for which the bail is not also permitted. So, it has to be necessarily a very serious offences. Then in such cases, private persons can also conduct the arrest, but then what is required is that immediately and not later than 6 hours. The maximum period is 6 hours, within which you have to turn in that person to the nearest police station. Then, if there is a reason to believe that such person comes under the provisions of subsection 1 of section 35, the police officer shall take him into custody. So, when the private person takes this accused, the one whom he has arrested, to the police station, the police officer shall make his own necessary inquiries, and if he feels that yes, there is a reasonable suspicion that this person needs to be arrested, the police officer shall take him in custody. And if there is reason to believe that he has committed a non-cognizable offence. See, an ordinary person might not be knowing the difference between a cognizable and a non-cognizable offence. So, if the police officer, he finds out that what has been committed is not a cognizable but a non-cognizable offence, and he refuses on demand of police officer to give his name and residence, or gives a name or residence which such officer has reason to believe to be false, then he shall be dealt with under provisions of section 39, but if there is no sufficient reason to believe that he has committed any offence, he shall be at once released. So, students, in this session we tried to understand what is the meaning of arrest, how it is different from custody, what are the guidelines to be followed while arresting a judicial officer, what are the conditions to be followed in arresting a person, and when can a person be arrested without warrant. So, this will be all for this session. In the next session, we will be talking about the rights of an arrested person, further conditions relating to arrest, and also processes to compel appearance of an accused, that is summons and warrants. So, all that would be discussed in the upcoming session. Hope you enjoyed this lecture. Thank you.